All right, everyone, settle in. Welcome to our special little study group for PP 5340 Introduction to Public Policy and Management. Today, we're pulling back the curtain on something foundational, something that guides the very notion of justice in Connecticut. We're talking about the Connecticut Prosecution Standards, a critical document that Deputy Chief State's Attorney John Riscato highlighted in his recent presentation. Our mission for this deep dive is to unpack these standards to give you, a shortcut to understanding the ethical and professional bedrock of prosecutorial work in this state. It's not just some dry legal text. It's really a living document that shapes public policy every single day.
Exactly. And what's fascinating about these standards, which have been formally adopted by the Chief State's Attorney and all 13 states' attorneys, is how they truly formalize an unwavering commitment to ethical conduct. They compile national best practices from organizations like the National District Attorneys Association and the American Bar Association, but they're carefully tailored for Connecticut's unique legal landscape. We're talking about the core guiding principles for everyone from the Chief State's Attorney right down to an Assistant State's Attorney and even other governmental attorneys who get cross-designated for prosecutorial duties. It's a remarkably comprehensive ethical framework for the entire division of criminal justice.
So by the end of this deep dive, you'll not only understand what these standards are, but more importantly, for our public policy focus, why they matter. We'll connect the dots to their real-world impact on public policy and the actual administration of justice. You'll gain a much deeper appreciation, I think, for the complex role prosecutors play, balancing the broad interests of society with the fundamental rights of every individual. Let's dig in. Okay, let's kick things off with the big idea then. What exactly is a prosecutor's core responsibility? I mean, many might think it's simply to win cases for the state, right? But these standards seem to suggest something much deeper.
That's a great starting point because it really sets the tone for everything else. The primary responsibility of Connecticut's prosecutors, who we call state's attorneys, is incredibly profound. While they are indeed members of the executive branch, their fundamental duty is to seek justice. This means protecting the innocent, respecting the constitutional and legal rights of all persons involved, and especially victims. They are truly envisioned as ministers of justice, which is, well, a far cry from just being aggressive advocates trying to secure a conviction at all costs.
That minister of justice concept is pivotal, isn't it? It immediately distinguishes them from, say, a defense attorney whose primary loyalty is unequivocally to their client.
It's a critical, almost philosophical distinction that profoundly shapes their unique obligations. Unlike defense counsel, who must defend their client whether innocent or guilty, a prosecutor represents society as a whole. This broader mandate means their role extends to ensuring procedural justice for the accused and making certain that any finding of guilt is based on sufficient and credible evidence. It's about upholding the system, not just, winning a specific outcome.
Right, and the standards don't just imply this. They explicitly quote a powerful line from Berger v. United States, a landmark Supreme Court case from 1935, stating a prosecutor may strike hard blows, but is not at liberty to strike foul ones. For us studying public policy and management, this raises a crucial question. How does this Minister of Justice role practically influence day-to-day decisions, especially when prosecutors are operating within an inherently adversarial legal system? It highlights a constant tension, I think, between seeking justice and the competitive nature of legal proceedings.
Building on that, this role also means prosecutors must exercise sound discretion and independent judgment. They serve the public interest, which is a broad and abstract concept, rather than specific government agencies, individual law enforcement officers, or even the immediate, often emotional interests of individual victims. In fact, societal interests are so paramount that prosecutors are even expected to be involved in advocating for criminal law reform when needed.
So this really emphasizes impartiality. It means a prosecutor shouldn't be swayed by pressure from a police department to pursue a case that lacks strong evidence, perhaps, nor by the understandable but sometimes unproven emotional appeals from a victim if the evidence just isn't there to support a charge. It demands a dispassionate assessment of the facts and the law.
Exactly. It's an ideal that, in practice, demands constant ethical navigation. I mean, imagine the challenge of balancing the very specific, often deeply emotional interests of an individual victim or a dedicated law enforcement agency with the broader, more abstract interests of society, which might sometimes mean declining a prosecution or offering a diversion. It requires a deep well of independent judgment.
Okay, this next point is a crucial one, especially for public policy. The standards take a very strong stance on the elimination of improper biases. It's not just about avoiding explicit discrimination based on race, sex, religion, national origin, disability, age, sexual orientation, gender identity, socioeconomic status, or political considerations. It goes deeper, requiring prosecutors to actively strive to eliminate implicit biases and to mitigate any improper bias when they are credibly informed it exists. The Division of Criminal Justice, or DCJ, is proactive in detecting and eliminating biases, particularly historically persistent biases like race. This isn't just about conscious intent anymore, it's a much more sophisticated understanding of how bias can operate.
Indeed, this moves way beyond simply condemning explicit discrimination. It acknowledges the pervasive and often unconscious impact of implicit bias on decision-making. The standards specifically cite Connecticut Supreme Court cases like State v. Holmes and State v. St. Call, which discuss how stereotypes, even when consciously rejected, can subtly but significantly affect perception and lead to biased decisions. This is a really progressive approach to fairness.
And to help with this, the document even points to resources like https://www.projectimplicit.net for individuals to identify their own implicit biases. Wow. The explicit focus on implicit bias and the need for regular self-assessment truly shows a sophisticated understanding of the systemic fairness challenges within the justice system. For public policy students, this is a prime example of policy evolving to meet a deeper understanding of societal issues. It makes you wonder what other policies could further support this critical goal of dismantling implicit bias.
And moving from individual conduct to institutional integrity, the standards lay out clear duties to report misconduct, both of others and against oneself. Prosecutors must first attempt to dissuade misconduct. If that fails or isn't possible, they must report it to the state's attorney for the judicial district or to the chief state's attorney if employed in that office. If a state's attorney is the subject, the report goes to the chief state's attorney or even to the Criminal Justice Commission. Importantly, serious violations like those described in Rule 8.3 of the Rules of Professional Conduct must be reported to the statewide Bar Council. This tiered reporting structure is really designed to ensure accountability at multiple levels, both internally and to external professional bodies.
So it's not enough to simply avoid misconduct. There's an active duty to address it in others. And the standards back this up with real consequences, right?
Absolutely. The standards explicitly refer to Connecticut General Statutes, Section 5127AB, which grants authority for discipline up to termination for serious misconduct. This shows a clear commitment to upholding a high standard of conduct across the board.
And just to clarify how these Connecticut prosecution standards fit into the broader legal framework, they are entirely consistent with and supplement the general rules of professional conduct for all lawyers. They're not a lower bar, but provide specific guidance for prosecutors, with Rule 3.8 explicitly covering the special responsibilities of a prosecutor.
That's right. If there were any inconsistency, the general rules of professional conduct would prevail. This layered approach ensures that prosecutors adhere to both the general ethical framework for all lawyers and the specific heightened ethical obligations of their unique role. It does raise an interesting question about the dynamic nature of ethics. How do these specific standards adapt as general legal ethics evolve?
Okay, beyond just core responsibilities, the standards also delve into what it means to act professionally. This seems to go beyond mere compliance with rules.
It absolutely does. Standard 1.2.1 emphasizes that professionalism demands integrity, fairness, and courtesy in all interactions. With victims, witnesses, law enforcement, opposing counsel, the court, jurors, and defendants. It encompasses everything from civility and punctuality to proper restraint and dignity. It explicitly prohibits actions like making disparaging remarks, proceeding inconsistently with court rulings, asking improper questions, or engaging in dilatory tactics.
That sounds like a significant challenge in the high-stress, often emotionally charged environment of a courtroom. I mean, how do you codify something like dignity?
You're right, it's described as a higher standard of conduct than simple rule following. It's about fostering an environment of trust and efficiency, preventing behaviors that could undermine the integrity and honor of the legal profession. For public policy, this is key. How do you foster such a culture of professionalism, especially when the system is inherently adversarial and emotions can run so high? It's about setting an expectation for conduct, not just avoiding rule violations.
And part of that professionalism is maintaining confidentiality, of course. Seems obvious, but critical.
Precisely. Standard 1 to 2.2 highlights that prosecutors are exposed to a vast amount of confidential information, governed by Rule 1.6a of the Rules of Professional Conduct. They must always remember that disclosure is generally prohibited without informed consent from the client, which again is the state and the public. This reinforces the critical importance of discretion when handling sensitive data on a daily basis.
Impartiality is crucial for justice, and the standards are very explicit about avoiding conflicts of interest. What are the key areas prosecutors need to navigate here?
Standard 1 to 3.1 on conflict avoidance is foundational. Prosecutors must be acutely aware of ethical rules regarding conflicts and sensitive to any facts that might even appear to create a conflict. They cannot hold interests or engage in activities, financial or otherwise, that conflict, have the potential to conflict, or are likely to create a reasonable appearance of conflict with their official duties.
And the standards get quite specific about what those conflicts might look like, don't they?
They do. Standard 1.3.2 lists specific conflicts, such as prosecuting former clients, handling matters where prior privileged information would be pertinent, or cases where a close family member, like a spouse, child, or sibling, or a lawyer with a significant financial relationship represents the defendant. The core principle is clear. Personal, political, financial, or any other external interest should never affect a prosecutor's professional judgment.
Does a conflict for one prosecutor automatically mean the entire office is out of the case? Not necessarily. The standards recognize that even the appearance of impropriety can erode public trust. However, a personal disqualification due to family ties is usually personal to that individual prosecutor and not automatically imputed to the entire office. Other prosecutors in the same office may still handle the case, sometimes with firewalls and filters in place, especially in larger offices. An illustrative example given is a prosecutor and a public defender who are married and can handle cases in the same court division, provided they don't directly oppose each other in any specific case. It's a pragmatic approach to managing unavoidable personal connections while maintaining integrity.
Okay, this next area is highly sensitive and directly relevant to public policy: police accountability and use of force investigations. Standard 1.3.5 directly addresses this. It says state's attorneys can investigate and prosecute excessive force cases that don't result in death. Correct. But here's the critical part. The standards strongly recommend recusal and the appointment of a prosecutor from another jurisdiction or the chief state's attorney's office if the state's attorney believes their office's relationship with the involved officer or agency would impact objective handling, or, importantly, if public perception of integrity would be negatively impacted, even if that perception is, in their view, unfounded. Furthermore, deadly force investigations are now handled by the independent office of the Inspector General.
This directly addresses a major public policy concern. It acknowledges that public perception matters, even if the office feels it can be objective. The creation of the Inspector General position in 2020 is a direct structural response to societal demands for greater independence in these investigations. From a public policy standpoint, how does the structural shift explicitly aim to bolster public confidence in police accountability? It seems like a really deliberate move. So, who exactly are these prosecutors? What are their roles? And how did they become part of the system? Understanding the hierarchy is fundamental for our public policy and management study, I think.
Absolutely. This section meticulously details the organizational structure of the Division of Criminal Justice, the DCJ, emphasizing a full-time commitment, rigorous qualifications, and accountability through robust peer review processes. The ultimate prosecutorial power in Connecticut is vested in the chief state's attorney and the state's attorneys.
Let's start at the very top then. The chief state's attorney, what's their role?
The chief state's attorney is a constitutional officer and the administrative head of the DCJ. Their duties are incredibly broad, really, ranging from establishing bureaus, adopting rules and guidelines, and engaging in long-range planning, to collecting statistical data, conducting research, developing training, coordinating with other agencies, and even auditing bills. This comprehensive list highlights vast administrative and policy-making responsibilities, far beyond just prosecuting individual cases. What's also notable is that the chief state's attorney is subject to a biennial evaluation and peer review by a committee of state's attorneys, ensuring consistent, evidence-based feedback at the highest level of leadership.
Okay. And below the chief state's attorney are the deputy chief state's attorneys.
Yes, there are two full-time deputy chief state's attorneys, one for operations and one for personnel, finance, and administration. They assist the chief state's attorney and have the authority to sign warrants and other official documents. A third DCSA is specifically appointed by the Criminal Justice Commission, excluding the chief state's attorney, to oversee the Office of the Inspector General, which is a deliberate choice to ensure that office's independence. Like the chief state's attorney, these deputy chiefs also undergo biennial peer review, ensuring accountability flows through the senior leadership ranks.
Then we have the state's attorneys themselves in each district.
The state's attorneys are the chief law enforcement officers in their respective judicial districts, holding office for 8-year terms. They are expected to possess deep expertise in criminal law and procedure, manage resources effectively, actively engage with their communities to foster trust, and adhere to agency-wide policies. They, too, are subject to a biennial peer review process conducted by a committee that includes the chief state's attorney, the deputy chief state's attorney for personnel, finance, and administration, and a senior state's attorney. This system is designed to provide comprehensive, constructive feedback to continuously improve performance and adherence to standards.
And what about the assistant and deputy assistant state's attorneys, who are really on the front lines in the courtroom?
These prosecutors are appointed by the Criminal Justice Commission based on recommendations and are subject to discipline, including termination, consistent with their collective bargaining agreements. This ensures a consistent standard of conduct and performance across all levels of the DCJ. Lastly, the division also employs inspectors who are appointed by the chief state's attorney or state's attorneys to assist with investigations, possessing the same arrest power as state police.
Understanding this intricate hierarchy is key to grasping how policy decisions from the top flow down to impact individual cases. For public policy students, what's particularly insightful here is the emphasis on full-time commitment for senior prosecutorial officials, prohibiting them from engaging in external legal practice. That seems like a deliberate policy choice to prevent conflicts of interest and ensure dedicated public service, safeguarding public trust in the integrity of the office.
Definitely. And beyond the structure, competence is explicitly addressed. Standard 1 to 4.8 emphasizes that prosecutors must possess the requisite legal knowledge and skill, continually staying abreast of legal, scientific, and technological developments. This acknowledges the dynamic nature of legal practice, especially with the increasing complexity of evidence and technological presentations in trials. Supervisors also have an independent responsibility to ensure competent performance from their staff.
All this complex work and these high standards must demand continuous training. How do these standards ensure prosecutors are constantly learning and developing their skills?
Training is really a cornerstone of the system. Standard 1 to 5.1 mandates that all prosecutors participate in formal training and continuing legal education, or CLE, programs from the moment they start their duties and regularly thereafter. The DCJ itself develops and maintains these programs, ensuring all staff attorney and non-attorney participate.
What kind of topics do these training programs cover to keep everyone sharp? It must be pretty broad.
Oh, the curriculum is incredibly diverse and comprehensive. It includes core areas like substantive law, rules of evidence, forensic evidence, and trial advocacy. But crucially, it also covers implicit bias, management skills, and ethical conduct. The DCJ's programs are specifically designed to exceed minimum state CLE standards, signaling a strong commitment to excellence. For instance, new deputy assistant state's attorneys are assigned a mentor and complete a basic orientation package that includes touring correctional institutions and attending court proceedings. The DCJ also hosts an annual statewide Connecticut prosecutor conference.
This raises a fascinating public policy question. How does this investment in continuous training, especially in areas like implicit bias and new technology, directly contribute to more just, equitable, and efficient outcomes in the criminal justice system? It's a clear demonstration of investing in the human capital of the justice system. Finally, for this part, let's tackle prosecutorial immunity. It's a topic that often comes up in public discussions about accountability. What does it actually entail?
This is a complex but crucial standard. Standard 1 to 6.1 outlines the scope of prosecutorial immunity, which generally grants absolute immunity from civil rights actions under 42 U.S.C. Section 1983. This applies when prosecutors are acting within the scope of their duties in initiating and pursuing criminal prosecutions. The purpose is to protect their vigorous and fearless performance of duty without the constant threat of frivolous lawsuits hindering their judgment.
Okay, so if they have this immunity from civil lawsuits, does that mean prosecutors can't be held accountable at all for misconduct? That seems problematic.
Not at all, and that's a key point. The Supreme Court case Imbler v. Pashman from 1976, which established this principle, explicitly clarified that immunity does not leave the public powerless to deter misconduct. Prosecutors can still be punished criminally for willful deprivations of constitutional rights under federal law, and they are fully amenable to professional discipline by bar associations. This highlights a critical balance. The public interest in an uninhibited prosecutor is prioritized over civil redress for a genuinely wronged defendant, but with alternative, robust accountability mechanisms in place.
So what does this balance mean for public trust? It's a tightrope walk.
It means the system is designed to encourage robust prosecution while still having crucial checks and balances through the possibility of criminal prosecution and professional discipline for severe misconduct. Furthermore, Connecticut statutes like CGS Section 5141 MOBE indemnify state employees, including prosecutors, against civil suits if they act within the scope of their duties and not wantonly, recklessly, or maliciously. This provides another layer of protection for actions taken in good faith within their official capacity.
Beyond the courtroom, a prosecutor's role extends into a vast network of relationships within the broader justice ecosystem. This section of the standards truly highlights how interconnected the system is. Let's talk about how they connect with other public services, national organizations, and the community.
Indeed, it's a web of interactions absolutely crucial for the effective administration of justice. Prosecutors are deeply embedded in the broader public service landscape.
And one important way they do this is by serving on various boards and commissions, right?
That's correct. Standard 2 1.1 emphasizes that prosecutors serve on various statewide commissions and boards, such as the Criminal Justice Information System Governing Board and the Sentencing Commission. This active participation ensures that prosecutorial input is integrated into broader policy and operational decisions across the state, ultimately enhancing the effectiveness, efficiency, and fairness of the criminal justice system as a whole. It's a mechanism for cross-agency collaboration at a policy level.
Okay, this next point is a huge one for public policy students. Data collection and sharing. Standard 2 1.2 mandates that the Division of Criminal Justice prioritizes capturing, tracking, analyzing, and sharing statewide criminal justice data, primarily through their e-prosecutor system. Why is this so vital?
This directly speaks to the goals of public policy and management. Data-driven practices are essential for evidence-based policymaking and fostering transparency in the criminal justice system. It allows the DCJ to identify trends, pinpoint disparities, allocate resources more effectively, and understand where improvements are needed across the state. Prosecutors are required to comply with all related policies, making data a central pillar of their operational framework. It's about moving beyond anecdote to informed decision-making.
And beyond the numbers, there's also direct community engagement mentioned in the standards. That seems important for building trust.
Absolutely. Standards 2.3.1 and 2.3.5 emphasize that the DCJ engages in proactive outreach efforts to build trust and establish relationships within communities. States' attorneys' offices are encouraged to build connections with local community-based organizations focused on crime prevention, justice enhancement, and offender rehabilitation. This proactive approach moves beyond mere enforcement to building genuine community partnerships and addressing the root causes of crime. Examples include engaging school officials, youth organizations, and neighborhood crime watch groups, fostering a sense of shared responsibility for public safety.
Let's shift our focus to law enforcement. Prosecutors and police are, of course, partners in justice, but what does that relationship specifically entail under these standards? It seems like it needs careful management.
It's a relationship built on close cooperation and shared goals, but with clear roles defined. Standard 2.5.1 emphasizes that prosecutors must maintain close, cooperative relationships with law enforcement, acknowledging their shared objectives of public safety and individual rights. They also play a vital advisory and educational role, informing agencies of case outcomes and providing critical legal guidance.
So prosecutors actually provide training for police officers? That's not something everyone might realize.
Yes, it's a significant part of their preventative role. Standard 2 to 5.4 makes it clear that prosecutors provide training on critical legal areas, such as search and seizure, the arrest process, use of force, interrogation techniques, and exclusionary rules. Experienced prosecutors can even become certified by POST, the Police Officer Standards and Training Council, to conduct both introductory courses for new recruits and continuing education for seasoned officers. This is crucial because the success of prosecutions and the protection of individual rights often hinges on proper law enforcement procedures. Prosecutors ensure investigatory methods are lawful and that evidence will be admissible in court.
And they provide direct legal advice to police during ongoing investigations as well.
Yes. Standard 2.5.5 specifies that prosecutors advise police on the legal aspects of criminal investigations, interpreting criminal laws, assessing the sufficiency of evidence, and guiding them on requirements for search warrants or electronic surveillance. This advice promotes lawful methods that will withstand judicial scrutiny. Importantly, they should not advise on civil or personal matters unrelated to criminal investigations. This practice ensures that law enforcement actions are legally sound from the outset, protecting both public safety and individual rights. It's a proactive step that can prevent later suppression of evidence.
The relationship with the court is obviously central to the entire system. How do these standards govern that interaction? Respect seems key.
It begins with fundamental respect. Standards 26.1 and 26.2 state that prosecutors must display proper respect for the judicial system and judges, maintaining courteous and civil working relationships. They're explicitly prohibited from making false or reckless statements about judicial qualifications or integrity. This reinforces the decorum and trust necessary for the judicial process to function effectively, upholding the dignity of the court.
What about private communications with judges outside of court? That's always a sensitive area.
Standard 26.4 on ex parte communications or submissions addresses this directly. Generally, prosecutors should not engage in ex parte or one-sided discussions or submissions with judges unless specifically authorized by law or court order. If authorized, they have a crucial ethical duty. They must inform the court of all material facts, including any adverse ones, to ensure the judge can make a fair and informed decision. For more generalized matters, like case management, defense counsel should be invited to join the discussion. This is a critical safeguard for the fairness and transparency of judicial proceedings.
Interesting. And it's powerful that prosecutors are also tasked with holding the judiciary itself accountable if necessary.
Absolutely. Standards 26.5 and 26.6 establish a prosecutor's duty to investigate reasonable suspicion of criminal activity or misconduct by members of the judiciary. If warranted, prosecution must be commenced. They also have a responsibility to report judicial incompetence. This portrays the prosecutor as a guardian against injustice and corruption at all levels of the system, a truly powerful statement about upholding accountability and the integrity of justice itself.
Now, let's explore the standards for how prosecutors deal with suspects and defendants. How do they handle communications with individuals who already have legal representation?
Standard 27.1 is unequivocal. Generally, prosecutors should not communicate directly with represented defendants about the subject of representation without defense counsel's consent or specific court authorization. This rule is fundamental to upholding the attorney-client relationship and preventing a represented party from being taken advantage of by opposing counsel.
Okay, that makes sense. But what about when defendants don't have a lawyer, which I understand is quite common in Connecticut, especially in lower courts? That's a different dynamic.
It is indeed a particularly sensitive area, and Standard 27.2 on communications with unrepresented defendants acknowledges Connecticut's unique challenge here. The source material highlights that Connecticut has a much higher rate of individuals representing themselves than observed in other states. So when communicating with these unrepresented defendants, prosecutors must ensure honesty, fairness, and full disclosure of potential criminal liability. They must clearly identify themselves as prosecutors and advise the defendant of their right to counsel. This means Connecticut prosecutors are often required to fill a unique educational role, explaining the legal process, available diversionary programs, and even plea offers. A role the standards note is typically not filled by prosecutors outside of Connecticut.
So, for you, our public policy listener, this reveals a distinctive aspect of Connecticut's justice system. The prosecutor's role extends to educate, becoming a significant departure from a pure advocacy role. It's a fascinating policy response to the prevalence of pro se defendants.
And this commitment extends to plea negotiations and the right to counsel. Standards 27.4 and 27.5 outline that prosecutors should advise unrepresented defendants on procedures for obtaining appointed counsel. Crucially, they should not obtain waivers of important pretrial rights from unrepresented accused persons. This balances the defendant's right to self-representation with the need to ensure the defendant is fully aware of the dangers and disadvantages of proceeding without counsel. An important protection is Connecticut Code of Evidence Section 4-A-3, which prohibits using statements made by a pro se defendant during unsuccessful plea negotiations against them at trial.
What about the relationship with defense counsel? While they are adversaries in court, professionalism is still absolutely expected, correct?
Absolutely. Standards 28.1 to 8.2 explicitly state that prosecutors must maintain courteous and civil working relationships with defense counsel, showing candor and fairness regardless of any personal feelings or prior animosity. This reinforces the core idea that the adversarial system is about seeking justice, not engaging in personal attacks. Maintaining professionalism is paramount to the system's integrity and public trust.
And they also have duties related to information sharing and reporting misconduct by defense attorneys, too.
Yes. Standard 28.4 requires prosecutors to cooperate by providing information and assistance, particularly related to discovery. And Standard 2A.6 mandates reporting ethical misconduct by defense counsel that raises substantial questions about their honesty, trustworthiness, or fitness. This ensures a level playing field and accountability across the legal profession, which is essential for a functional justice system.
Moving on to victims, these standards seem to place a huge, almost constitutional emphasis on their rights and support within the justice system.
They absolutely do. This section is quite extensive, detailing specific rights enshrined in both the state constitution and statutes. Standards 2 to 9.1 and 2 to 9.2 underscore the prosecutors must recognize and meticulously comply with victims' constitutional and statutory rights. These include the right to be treated with dignity, protection from harassment, access to information about their case, presence at proceedings, communication with the prosecution, and critically, the opportunity to make a statement at plea or sentencing. Prosecutors must also maintain consistent communication and provide a clear point of contact for victims.
That sounds like a very detailed set of rights intended to empower victims within the process.
It is. For example, victims have the right to attend proceedings unless they are scheduled to testify and their presence would materially affect their testimony. They also have the right to object to or support plea agreements and to make a statement to the court at sentencing, ensuring their voice is heard at critical junctures. This demonstrates a very clear commitment to empowering victims within the process.
How do the standards ensure victims receive practical support beyond just their legal rights? Is there infrastructure for that?
Yes, Standards 2.9.3 and 2.9.4 detail a multifaceted approach to victim support. Prosecutors work closely with victim services advocates and the Office of the Victim Advocate to ensure victims are fully apprised of their rights, receive proper notice, and have their voices heard. This assistance includes essential referrals to social service agencies, clear explanations of the criminal justice process, safety planning, which is especially crucial for victims of domestic violence, and help with compensation programs for injuries.
What's the distinction between the Office of Victim Services and the Office of the Victim Advocate? They sound similar.
That's an important distinction for public policy. The Office of Victim Services provides direct services and administers the Criminal Injuries Compensation Fund, which covers medical expenses, counseling, lost wages, and funeral costs, though notably not property loss. They also fund family violence victim advocates and community advocates who provide direct support. The Office of the Victim Advocate, however, is an independent oversight agency. Its specific charge is to promote, protect, and enforce victims' constitutional and statutory rights throughout the state. So if we connect this to the bigger picture, it demonstrates how the public policy of victims' rights has evolved into the creation of both specific direct services and independent advocacy roles within the justice system, ensuring comprehensive support and oversight.
And for victims facing actual physical danger, there's a specific protection program mentioned.
Yes. Standard 2.9.7 refers to the Leroy Brown Jr. and Karen Clark Witness Protection Program. This program is available for witnesses and victims in serious felony cases who are facing substantial danger from intimidation or retaliatory violence. It provides temporary or semi-permanent housing, basic living expenses, and police protection. It's a vital tool for ensuring testimony in the face of threats.
Witnesses are obviously crucial to any successful case. What guidelines exist for how prosecutors should interact with them?
Standard 210.1 is comprehensive. It outlines that prosecutors should interview all witnesses fairly without misrepresenting their status, intimidating, or unduly influencing them. They must avoid using means that would embarrass, delay, burden, or violate legal rights, and maintain cordial professional relationships, avoiding inappropriate personal ones. This ensures ethical and legal interactions to secure reliable testimony, respecting the witness's role in the process.
Okay, but what if a witness might inadvertently say something that could incriminate themselves? How does a prosecutor navigate that ethical minefield?
Standard 210.5 addresses this directly. Prosecutors should advise a witness of their rights against self-incrimination and their right to counsel when legally required. And even if not strictly required, they should do so if they reasonably believe the witness may provide self-incriminating information and appears unaware of their rights. However, a crucial ethical boundary is that they should not advise or exaggerate potential criminal liability to deter a witness from testifying. This raises an important ethical question for public policy. How does a prosecutor balance the need for truthful testimony with the ethical duty to protect a witness who might inadvertently incriminate themselves? It's a delicate balance of competing interests.
Right. It's also critical that witnesses aren't discouraged from speaking with the defense, even though they're often key to the prosecution's case.
Absolutely. Standard 2 10.8 explicitly states that prosecutors should not discourage or obstruct communication between witnesses and defense counsel, nor advise witnesses to decline meeting with the defense. This preserves the integrity of the adversarial process and prevents interference with the defendant's constitutional right to gather evidence and prepare defense.
Now, cooperating witnesses and jailhouse witnesses can be very sensitive topics, often generating controversy. What do the standards say here to ensure transparency and prevent manipulation?
These are indeed highly scrutinized areas, and Standards 210.9 and 210.10 address them with very specific requirements for transparency and preventing manipulation of testimony. Cooperation agreements with witnesses must be in writing, accurately reflecting the entire agreement, and probably disclosed to the defense. Prosecutors cannot grant immunity for perjury. For jailhouse witnesses, informants who provide testimony in exchange for consideration in their own cases, prosecutors must strictly comply with statutory requirements, including disclosure, tracking, and reporting, such as those found in Connecticut General Statute Section 54 De Habeas Sex. Protective orders may be sought to protect these witnesses, given their vulnerability.
And there's even a system to track these specific types of witnesses. That's a very concrete policy mechanism.
Yes, the jailhouse witness statute requires disclosing details like the witness's criminal history, any benefits they received, and their prior testimony. There's even a jailhouse witness tracking database, which you can find online. This level of detail in the standards ensures accountability and transparency in what can be a complex and often controversial area of prosecution.
What about child witnesses? They're particularly vulnerable in the judicial system. Are there special considerations?
Yes, definitely. Standard 210.110 mandates that prosecutors be aware of special procedures designed to minimize emotional effects on child witnesses. This can include closed-circuit television testimony, which is allowed by Connecticut General Statutes Section 5486G for children 12 or younger to testify outside the courtroom without seeing or hearing the defendant. Other accommodations like comfort objects, such as stuffed animals during testimony, are also permitted. This balances the defendant's Sixth Amendment right to confrontation with the state's interest in obtaining reliable testimony from vulnerable witnesses. It's a policy designed to protect children while upholding fair trial rights.
The media plays a significant role in public perception of the justice system. How do prosecutors balance the need for transparency with ensuring a fair trial, which could be prejudiced by media coverage? It's a tough line to walk.
Standards 214.1 and 214.4 navigate this complex tension. Prosecutors should maintain a professional relationship with the media to facilitate the appropriate flow of information to the public. They may comment on public record details, such as the accused's name, the charges, findings of probable cause, and the court schedule. However, they must avoid comments that would prejudice a criminal proceeding, such as those related to a defendant's character, guilt or innocence, witness credibility, or details of plea negotiations. This draws heavily from Rule 3.6 of the Rules of Professional Conduct, which governs all attorneys.
What if defense counsel makes public statements that might be prejudicial? Can prosecutors respond?
Standard 214.6 permits prosecutors to make reasonable and fair replies to public statements by defense counsel or others if it's necessary to mitigate undue prejudice created by those statements. However, these responses must be limited and cannot violate the prohibited content mentioned earlier. It's a narrow exception, not a free pass to engage in a media war.
Interesting. And what if a prosecutor wants to offer generalized commentary to the media about the justice system, not necessarily about a case they're involved in? Is that allowed?
Standard 214.11 makes a fascinating distinction. A prosecutor uninvolved in a specific case may offer generalized commentary to educate the public about the criminal justice system, provided it doesn't risk prejudicing an ongoing criminal proceeding. They are expected to be well-informed and accurate. However, they should generally not comment on the specific merits of an ongoing case, except in very rare instances of manifest injustice. This raises an interesting public policy question. How fine is the line between educating the public about the justice system and risking prejudice in a high-profile case? The distinction for uninvolved prosecutors is a key policy detail. Hashtag 1015, funding entity and 16. Non-governmental entities.
Let's consider the financial aspects of the justice system. Public trust is obviously paramount when it comes to how the system is funded and whether those funds could create perverse incentives.
Absolutely. Standard 215.2 directly addresses this by stating that the Division of Criminal Justice budget should be independent of and unrelated to revenues generated from law enforcement activities like fines and forfeitures. Any appearance of impropriety in such an arrangement is deemed untenable. This is a clear ethical boundary in public policy, explicitly designed to ensure that prosecutorial decisions are driven by justice, not by financial incentives or revenue generation for agencies, thereby maintaining public trust in the motivations behind prosecutions.
And what about accepting help from non-governmental sources? Can the DCJ take private money or resources?
Standard 216.2 allows the DCJ to accept financial or resource assistance from non-governmental sources, but only if specifically approved by the Chief State's Attorney. Priority must always be given to the public interest over private interests, especially for specific cases, and great care must be taken to avoid even the appearance of undue influence. Strict bookkeeping and disclosure are required. The sources provide a great example of this. The DCJ has received grants from the Herbert and Nell Singer Foundation, Inc., partnering with the Center for Court Innovation, now the Center for Justice Innovation, for programs like the Early Screening and Intervention Program, or ESI.
That sounds like a really interesting public-private partnership for justice reform. How does that work?
It is. The ESI program, which is a key prosecutorial-led diversion model, demonstrates how innovative funding models can support justice reform. It diverts low-level offenders to treatment, unburdens court dockets, and conserves resources. For public policy students, this is a prime example of how creative funding models can support innovative programs like ESI, addressing underlying causes of criminal behavior and improving the efficiency and effectiveness of the justice system.
The prosecutor's role begins well before a case ever reaches a courtroom, specifically in criminal investigations. How did these standards guide them in the pursuit of truth while maintaining strict ethical boundaries?
This is a fundamental starting point for any investigation. Standard 3-1.2 clearly states that criminal investigations should not be motivated, in whole or in part, by a victim or perpetrator's race, ethnicity, religion, sexual orientation, or political affiliation, unless these are actual elements of a crime or directly relevant to motive. Nor should investigations be driven by partisan political pressure, professional ambition, or improper personal considerations. This standard underpins the principle of equal justice, ensuring investigations are objective and fair, which is essential for public confidence.
So the motivation behind an investigation is just as important as the outcome. What about the evidence itself? Who's responsible if it's obtained improperly?
Standard 321.3 clarifies that prosecutors are ultimately responsible for evidence used in a criminal case. If a prosecutor knows or is aware of a substantial risk that an investigation was conducted improperly or that evidence was illegally obtained by law enforcement, they must take affirmative steps to investigate and remediate such problems. This responsibility extends beyond their personal conduct to overseeing the conduct of agents, like law enforcement officers, and actively addressing any issues that arise. Standard 3.1.4 reinforces this by prohibiting prosecutors from knowingly obtaining or encouraging others to obtain evidence illegally or unethically.
Okay. What happens if privileged attorney-client information is accidentally obtained during an investigation? That could compromise a fair trial significantly.
Standard 3.1.5 addresses this by requiring immediate decisive action. If prosecutors or investigators inadvertently obtain or view materials containing privileged attorney-client information, they must immediately cease reviewing it, notify opposing counsel, and if the material contains case-related privileged information, they must recuse themselves. In such cases, a taint team might be brought in to review the material to ensure the sanctity of the attorney-client privilege is protected. This recognizes the profound impact such information could have on a fair trial and the importance of safeguarding fundamental legal rights.
This brings us to a critical gatekeeping role for prosecutors, the review of warrants. This is where individual liberty often hangs in the balance, right?
Indeed. Standards 3.2.1 and 3.2.2 require that states' attorneys' offices must provide prompt legal review for all arrest, search, and tracking device warrant applications before they're submitted to a judge. This is a crucial procedural step unique to Connecticut. State law requires prosecutor approval before a judge can even issue an arrest warrant. This makes the prosecutor a critical gatekeeper in the process, demanding that they have up-to-date knowledge of search and seizure law, which is a constantly evolving area. The Appellate Bureau, for example, assists trial prosecutors with new court decisions and training to meet this need.
So what exactly are prosecutors looking for when they review these warrants? It's more than just a rubber stamp, I assume?
Oh, far from it. Standards 3.2.3 and 3.2.4 detail a rigorous review process. For search and tracking device warrants, prosecutors must ensure there's probable cause-meaning facts supporting a belief of criminal activity or the location of evidence. They also scrutinize the veracity of affiance and the accuracy of information, especially from confidential informants, and ensure affidavits are not misleading or omitting material information. They may also consider seeking orders to seal affidavits if necessary for safety or ongoing investigations. For arrest warrants, the bar is even higher. Prosecutors must believe there will be sufficient admissible evidence at trial to establish each element of the crime charged, going beyond mere probable cause.
That's a significant distinction. It's not just about probable cause for the arrest itself, but enough evidence to believe a conviction is possible at trial.
Wow. Precisely. The review process demands a practical, common-sense decision, not just a formulaic one. Prosecutors must consider the four corners of the affidavit, assess the reliability of hearsay or informant information, and account for the staleness of information. This higher standard for signing an arrest warrant application, the belief of sufficient admissible evidence for conviction, reflects the profound impact of initiating charges on an individual's life. For public policy, this crucial role in vetting warrants protects citizens from unlawful searches and arrests and ensures the integrity of the evidence presented in court. The higher bar for arrest warrants beyond mere probable cause is a powerful acknowledgement of the weighty effects of charging decisions. And to maintain accountability and transparency, Standard 32.5 requires that all warrant applications submitted to the state's attorney's office must be tracked in the e-prosecutor system, with documentation of the review and any request for additional action by law enforcement. This creates a clear audit trail for these critical decisions. #3. Grand jury investigations.
Grand jury investigations have their own unique rules, especially regarding witness rights, given their often secretive nature. What do the standards say?
Standard 3.4 emphasizes that prosecutors must ensure grand jurors inform witnesses of their right to counsel, and, crucially, if a witness is a target of the investigation, their right against self-incrimination. Prosecutors should not object to reasonable requests for counsel to be present in the grand jury room. This ensures fairness and protects the constitutional rights of witnesses, even in a setting that can otherwise feel intimidating. #5. Grants of immunity.
Grants of immunity are a powerful tool in investigations, but they seem like they could come with strict conditions to prevent abuse.
They certainly do. Standards 3.5.1 and 3.5.2 require that grants of immunity must receive prior approval from the state's attorney after careful consideration of the public interest. They must always be in writing and precisely describe the scope of the immunity. Critically, immunity is specifically for compelling truthful testimony for state's evidence, not for condoning or immunizing perjured testimony. Immunity is a powerful tool, typically reserved for situations where a witness's testimony is crucial for prosecuting more serious crimes or co-defendants, and it must be used judiciously and transparently.
What about compelling testimony for the defense? Can the prosecution be compelled to grant immunity to a defense witness?
Standard 3.5.4 highlights a key difference in the prosecutorial role. Under Connecticut law, prosecutors are generally not obligated to grant or seek immunity to compel information on behalf of a defendant, except as otherwise required by law. This raises an important question for public policy about the balance of power in evidence gathering, where the state has a unique power to compel testimony through immunity that the defense generally does not possess.
Okay. Now we move into the pre-trial phase, where many critical decisions are made that truly shape a case before it ever sees a courtroom. Let's start with screening and charging, which involves a huge amount of prosecutorial discretion and policy implications.
These are arguably among the most paramount decisions a prosecutor makes. Standards 4.1.1 and 4.1.2 outline that prosecutors must possess a fundamental understanding of how criminal cases are initiated, from post-arrest procedures to formal docketing in court. While law enforcement may lodge charges at the time of arrest, prosecutors must evaluate these charges at the earliest practical time to determine if they should actually be pursued.
This sounds like a unique procedural reality in Connecticut compared to some other states. Is that right?
It is. Connecticut law lacks a mechanism for prosecutors to screen cases before they are officially docketed, meaning prosecutors are often reviewing charges after an arrest has been made and the case formally begun, rather than pre-screening all arrests. This adds a layer of complexity to their gatekeeper role, emphasizing the importance of their post-docketing review and independent judgment.
And all of this falls squarely under the umbrella of prosecutorial discretion, then.
Exactly. Standard 4.1.3 emphasizes that the chief state's attorney and state's attorneys must recognize and underscore the profound importance of these initial screening and charging decisions, providing appropriate training and guidance to prosecutors regarding the exercise of this discretion. This broad discretion is acknowledged in Connecticut case law.
So when making these crucial decisions, what specific factors should a prosecutor consider? And equally importantly, what factors should they not consider? There must be clear guidelines.
Standards 4.1.4 and 4.1.5 provide a detailed ethical framework for these decisions. Prosecutors should screen to eliminate cases that are not justified or not in the public interest. Factors to consider include the nature and severity of the offense, the probability of conviction based on admissible evidence, the accused's characteristics and criminal history, the deterrent value of prosecution, the accused's willingness to cooperate, their mental status, potential undue hardship on the accused, any history of non-enforcement of the law enforcement failures, and the size of the loss or harm. Crucially, factors not to consider include race, sex, religion, national origin, sexual orientation, political association or belief, or the prosecutor's personal financial or political interests. The standards also explicitly prohibit overcharging, that is, charging a more serious offense than the evidence warrants, solely to leverage a plea agreement.
Right, the overcharging point seems really important. This raises an important, almost perennial question central to public policy and management. How does a prosecutor truly balance the severity of a crime with the individual circumstances of the accused to genuinely serve the interests of justice and avoid unwarranted harshness? This is a clear ethical safeguard against improper influences in the most impactful decisions they make.
And this isn't a one-time decision either. Standards 4.1.7 and 4.1.8 impose a continuing duty on prosecutors to evaluate cases and reevaluate earlier decisions if new information arises that changes the calculus. Reasons for declining prosecution must be accurately entered and retained in the prosecutor system, providing a transparent record of these critical discretionary actions and allowing for accountability.
Beyond traditional prosecution, the standards also strongly encourage diversionary programs, offering alternatives to simply going through the full court system. This sounds like an important public policy tool.
Yes. Standard 4.3.1 highlights that cases can be diverted through prosecutorial-led diversion at the prosecutor's discretion, or through court-sanctioned programs, such as accelerated pretrial rehabilitation or the supervised diversionary program for veterans. Prosecutors must be thoroughly aware of the scope and availability of all these programs to appropriately guide cases.
So diversion is a recognized path for less serious offenders, aiming for something beyond just punishment, more rehabilitative.
Exactly. Diversion offers a path to address underlying issues like substance abuse or mental health challenges, which can lead to more effective long-term outcomes for individuals and society than traditional incarceration for certain low-level offenders. The Early Screening and Intervention Program, or ESI, which we discussed earlier in the context of private funding, is a key prosecutorial-led diversion model in Connecticut. Other examples include court-sanctioned programs like AR and the Veterans Program. If we connect this to the bigger picture for public policy, diversion programs are a prime example of innovation aimed at reducing recidivism, unburdening courts, and achieving more holistic justice. What's fascinating here is how prosecutors are even encouraged to make pro se defendants aware of these options, further expanding their educational and guidance role.
Let's quickly touch on the initial court proceedings after an arrest, starting with arraignment. What are the key duties there?
Standard 4.4.1 on prosecutorial responsibility states that prosecutors must ensure the court and the defendant, or their counsel, receive documentation sufficient to support a probable cause finding at arraignment. They also have a critical duty to redact victim names and addresses in sensitive cases like sexual assault or risk of injury, as required by statute, to protect vulnerable individuals.
Okay. And then there's the important issue of pretrial release and bail. What's the prosecutor's role there? They don't set bail, but they influence it.
Standard 4.5.2 on bail amount request outlines that prosecutors have a significant responsibility in bail determinations, considering factors like flight risk, potential danger to the community, and potential harm to witnesses. Critically, Standard 4.5.4 imposes a continuing obligation on prosecutors to seek bail modification if new information arises that makes the original decisions inappropriate. While courts ultimately set bail, prosecutors significantly inform that process. The standards acknowledge that pretrial detention has serious consequences, affecting employment, housing, family, and even increasing the likelihood of conviction, and express a preference for release, while also allowing for higher bail where there's significant documented risk. This ongoing review of bail conditions reflects a commitment to balancing public safety with individual liberty as new information emerges, which is a key public policy challenge.
Forfeiture laws, where property or assets linked to crime can be seized, can be a powerful tool, but they're also potentially prone to abuse if not carefully managed. How did the standards address this ethical tightrope?
Standard 4.7.1 on forfeiture laws states that prosecutors should make appropriate use of forfeiture statutes for money and property used in or obtained from criminal activity. However, Standard 4.7.5 impermissible considerations directly addresses the potential for conflicts of interest. It explicitly states that the availability of forfeited assets to fund law enforcement should not unduly influence discretion in enforcing these statutes or the criminal law. The purpose of forfeiture is to deter criminal conduct and remove instrumentalities or proceeds, not to substitute for criminal prosecution or to generate revenue for agencies. This is a clear ethical boundary in public policy, aimed at preserving the integrity of the justice system and avoiding even the appearance of a profit motive influencing prosecutorial decisions.
Discovery is a cornerstone of fair trials, ensuring the defense has access to information that allows them to prepare. What are the prosecutor's comprehensive obligations here? This seems absolutely critical.
Standards 4.8.1 and 4.8.2 outline expansive duties. Prosecutors have constitutional, statutory, and ethical obligations to disclose evidence to the defense. This includes inculpatory evidence, which the state intends to use, exculpatory evidence, which is helpful to the defendant, and impeachment evidence, which could undermine a witness's credibility. Importantly, this is a continuing duty throughout the entire case, meaning new evidence must be disclosed as it becomes known. This is a cornerstone of fair trial rights, rooted in landmark Supreme Court decisions. The prosecution team is broadly defined to include all law enforcement, meaning evidence known to police is imputed to the prosecutor.
Wow. So that means prosecutors have to actively seek out and disclose information that might even weaken their own case, not just evidence that supports it.
Exactly. Exculpatory evidence could include inconsistent witness statements, not matching perpetrator descriptions, or a witness's inability to identify a suspect. Impeachment evidence could involve a witness's arrests, prosecutions, or confessions that show the state has power over them. For you, the listener, this standard is vital for ensuring fairness and due process, preventing conviction of the innocent, and ensuring defendants can mount an effective defense. What's truly insightful here is the active role required of prosecutors to seek out potentially damaging evidence to their own case, emphasizing their minister of justice role over simply winning. And Standard 4.8.6 also addresses the protection of personal identifying information. Courts may issue protective orders to deny, restrict, or defer discovery to protect third parties or personal identifying information. Materials can be lodged with the court under seal for in-camera review, balancing transparency with necessary privacy and safety concerns.
Finally, let's look at case scheduling, which is critical for efficiency and preventing undue delays in the justice system. Justice delayed is justice denied, as they say.
Right. While the court ultimately controls scheduling, Standards 4.9.1 and 4.9.2 state that prosecutors must cooperate diligently with the clerk. They should not cause delays due to lack of preparation or for the purpose of disadvantaging the defendant. Continuances should only be sought for good cause, such as illness, witness unavailability, or the need for scientific testing. The principle here is that delays harm society, victims, and defendants alike, so prosecutors are expected to be diligent and avoid unnecessary delays. There are even rules allowing for sanctions against counsel who delay cases unnecessarily.
And speedy trial rights are a major constitutional consideration here, too.
Absolutely. Standard 4.9.3 requires prosecutors to be familiar with speedy trial rights under both the U.S. and Connecticut constitutions and state statutes. They must be aware of time limits and excludable periods, working proactively with the court to ensure prosecutions aren't jeopardized by delays. This is crucial for constitutional rights and reflects a public policy commitment to timely justice for all parties involved.
Now we're moving into some specialized areas of prosecutorial work, starting with juvenile justice, which has a distinctly different focus than the adult system, right?
Yes, this is a particularly insightful section that highlights a different philosophical approach. Standard 5.1.1, Primary Responsibility of Prosecutors in Juvenile Court, clarifies that while juvenile prosecutors seek justice and represent the state's interests, prioritizing community safety and victim welfare, they also must consider the juvenile's special circumstances and rehabilitative potential, but without unduly compromising community safety.
This sounds like a very different philosophy from the adult criminal justice system's primary focus on punishment, a real balancing act.
It is. This standard explicitly acknowledges the distinct philosophy of juvenile justice, which inherently balances accountability with rehabilitation, contrasting sharply with the adult system's primary focus on punishment. It's also important to note a key procedural difference. Juvenile cases are handled in the Family Division of Superior Court in the juvenile's residence jurisdiction, not where the alleged act occurred. For public policy students, this is a clear example of a distinct approach to young offenders that prioritizes long-term well-being and crime prevention alongside public safety. Standard 5.1.2 further emphasizes this specialized approach by requiring that Connecticut employs full-time juvenile prosecutors who receive specialized training, including adolescent development, in addition to general prosecutorial training. This specialized knowledge is crucial for handling these unique cases effectively. And in terms of outcomes, Standard 5.1.7 states that prosecutors actively participate in dispositional hearings, making recommendations consistent with community safety, seeking victim input, and critically, considering the juvenile's rehabilitative needs.
Plea agreements are a huge part of how criminal cases are resolved in the U.S. What are the standards governing these negotiations in Connecticut? Seems like a place where fairness is paramount.
Standard 6.1.1 on propriety clarifies that while prosecutors are not obligated to offer plea agreements, they may engage in negotiations if it's determined to be in the public interest. Crucially, similarly situated defendants should have substantially equal opportunities for plea agreements, and decisions should not be based on protected characteristics like race, religion, sex, or sexual orientation. This highlights the discretionary nature of plea bargaining while setting clear ethical guidelines for ensuring fairness and equity within the process.
And again, the importance of defense counsel in these negotiations is strongly emphasized.
Yes. Standard 6.2.2 states that prosecutors should not negotiate directly with a represented defendant unless defense counsel is present or has given express permission. This reiterates the importance of the attorney-client relationship, even in the context of plea negotiations, protecting the defendant from being taken advantage of and ensuring a level playing field.
What factors actually go into deciding what kind of plea offer to make? It must be more than just the charge itself, right? It needs to be individualized.
Standard 6.3.1 provides a comprehensive list for prosecutors to consider before negotiating a plea agreement. These factors include the nature and degree of the offense, any specific mitigating circumstances, the defendant's age, background, criminal history, and expressed remorse. They also consider the sufficiency of admissible evidence, the deterrent value of a trial versus a plea, how the plea might aid other prosecution goals, any history of non-enforcement of the law, potential legal rulings by the court, and the probable sentence if convicted at trial. This ensures thoughtful, individualized plea offers, aiming for a just and appropriate resolution that considers all relevant aspects. A critical safeguard is found in Standard 6.4.4 regarding the rights of others to address the court. Prosecutors must scrupulously honor victims and other authorized persons' legal rights to address the court. Importantly, prosecutors cannot commit, as part of a plea agreement, to limit or curtail these legal rights at the time of plea or sentencing. This standard explicitly safeguards the victim's voice within the plea process, ensuring their input is not silenced or circumvented by an agreement between the state and the defendant. This is a very strong policy statement.
And what about when charges are simply dropped by the prosecutor? What's the protocol for that? It's called a noli, right?
That falls under Standard 6.5.2. Reasons for nolle prosequi. When criminal charges are dismissed via a nolle prosequi, which is a prosecutor's formal declaration of unwillingness to prosecute, the prosecutor must state the reasons on the record in open court and enter them in the prosecutor system. If the nolle prosequi is bargained for as part of a plea agreement, it acts as a dismissal. However, if it's not part of an agreement, the defendant can technically still be prosecuted later on a new information, though that's less common. This is a deep dive into a specific legal mechanism, clarifying its implications and the prosecutor's responsibility for transparency and accountability in those decisions. Reasons for a nolle can often include the defendant's contributions to victim compensation or community service, demonstrating a rehabilitative or restorative justice approach.
The trial itself is the most public phase of the justice system, the focal point for many. How do these standards guide a prosecutor's conduct and responsibilities once they step into that courtroom?
Integrity is absolutely paramount in the courtroom. Standards 7.1.1 and 7.1.3 embody the fundamental duty of candor toward the tribunal. Prosecutors must not knowingly make false statements of fact or law to a court and must promptly correct any incorrect previous statements, even if they were made inadvertently. They must offer truthful and accurate evidence and take reasonable remedial measures if they learn that previously presented material evidence is untruthful or inaccurate.
So it's not enough to just avoid lying. They have to actively correct misinformation, even if they themselves didn't intentionally present it. That's a very high ethical bar.
Exactly. This is a fundamental ethical duty, drawing directly from Rule 3.3 of the Rules of Professional Conduct. The standards cite landmark cases emphasizing the prosecutor's obligation to correct substantially misleading testimony from witness, even if the witness didn't intend to lie. This is critical for the integrity of the judicial system. It demonstrates the prosecutor's unique role as a minister of justice, where even subtle misrepresentations must be corrected to ensure a fair and just outcome, prioritizing truth above all else.
Jury selection is often seen as where the fairness of a trial truly begins. What knowledge and procedures are expected of prosecutors here to ensure impartiality?
Standards 7.2.1 and 7.2.2 require prosecutors to be thoroughly knowledgeable about jury selection laws, including the rules for challenges for cause, where a juror demonstrates bias, and peremptory challenges, which traditionally don't require a stated reason. During voir dire, the examination of prospective jurors, the goal is to gather information relevant to intelligently exercising those challenges, not to commit jurors on factual issues or to present arguments. It's about meticulously ensuring an impartial jury, which is a core constitutional right.
Okay, but this next point is a critical and progressive development for public policy. The standards specifically address peremptory challenges and implicit bias, particularly through Connecticut's new Superior Court rule, which significantly moves beyond the traditional Batson framework. This sounds groundbreaking.
It really is. This is truly a groundbreaking development in criminal justice policy, directly confronting systemic bias. Connecticut has moved beyond Batson's requirement to prove purposeful discrimination, recognizing that implicit bias can still lead to discriminatory outcomes even without explicit intent. Under this new rule, a peremptory challenge can be disallowed if an objective observer, considering factors like disparate questioning, disproportionate use against a specific race or ethnicity, and the relevance of race or ethnicity to the case facts, would legitimately perceive the prospective juror's race or ethnicity as a factor in the challenge without needing to find purposeful discrimination.
That's a huge shift, moving from proving intent to addressing the effect and appearance of bias. What does that mean in practice?
Precisely. The rule even lists certain reasons that are now presumptively invalid for a peremptory challenge because they have historically been associated with improper discrimination or may be influenced by implicit bias. These include, for example, a prospective juror having prior contact with law enforcement, residing in a high-crime area, expressing distrust of law enforcement or the criminal justice system, or having a close relationship with people who have been arrested or convicted of a crime. This policy represents a profound commitment to equity and fairness in jury selection. For public policy students, this asks, how will this groundbreaking policy impact jury diversity and the fairness of trials in Connecticut, and could it become a model for other states? It's a testament to an evolving justice system actively seeking to dismantle systemic biases.
Let's discuss how prosecutors articulate their case in court, starting with opening statements. Are they always required?
While not standard practice in Connecticut to always give an opening statement, if permitted by the trial court, Standard 7.4.1 states that opening statements outline facts expected to be proven to the jury. Standard 7.4.2 sets strict ethical limits. Prosecutors must not argue law, express personal opinions, vouch for the credibility of witnesses, make inappropriate appeals to emotion or prejudice, or comment on a defendant's constitutional right to remain silent. It's about setting the stage, not making the argument yet.
And similar ethical rules apply to closing arguments, which are the final chance to persuade the jury, right? No personal opinions allowed.
Exactly. Standard 7.8.1 requires prosecutors to be well-versed in case law governing closing arguments and to prepare forcefully based strictly on the evidence presented. However, Standard 7.8.4 explicitly states that they cannot express personal opinions on the defendant's guilt, the credibility of witnesses, or the justness of their cause, as per the rules of professional conduct. Both opening and closing arguments require careful adherence to these ethical boundaries to ensure a fair trial based on evidence and law, not on personal beliefs or emotional appeals.
Finally, during the trial itself, how should prosecutors examine witnesses, whether for the prosecution or cross-examining for the defense? It needs to be fair.
Standard 7.6.1 dictates that prosecutors must conduct witness examinations fairly, avoiding harassment, undue burden, or violating legal rights. This ensures that testimony is elicited respectfully and legally. Additionally, Standard 7.6.2 notes that courts may order witnesses sequestered, meaning prevented from being in the courtroom during other testimony, to preserve the independence of witness testimony and prevent their accounts from being influenced by what they hear others say.
We've covered the trial, but the justice system continues long after a verdict. Let's look at the prosecutor's role in sentencing and then in post-sentencing considerations, which can sometimes unfold years later.
At this crucial stage, even after a conviction, the prosecutor's role remains one of seeking justice, not simply maximizing punishment. Standards 8.1.1
and 8.1.2 outline that the prosecutor's role at sentencing is to ensure a fully informed, fair, just, and equitable judgment, actively working to avoid unfair sentences and disparities. They inform the judge of the offenses, summarize relevant facts, disclose information from state files, present reports, correct any inaccuracies, and ensure victims have the opportunity to make impact statements to the court.
So the prosecutor is still very much acting as a minister of justice at sentencing, providing comprehensive information rather than just asking for the harshest penalty possible.
Exactly. The prosecutor is often the most knowledgeable party about the nuances of the case and the defendant's background, playing a crucial role in shaping the court's sentencing decision. This reinforces that minister of justice role. Court rules also outline the court's responsibilities at sentencing, including allowing victim impact statements and requiring the court to state its reasons for the sentence imposed on the record.
What about when someone violates their probation? That's a common post-sentencing issue. What's the process there?
Standard 8.2.4 clarifies that prosecutors review warrant applications from probation officers for alleged violations and pursue charges if an offender's noncompliance demonstrates that the beneficial aspects of probation are no longer being served. At any probation revocation proceeding, the state must prove the violation by preponderance of the evidence. Case law clarifies that willfulness isn't required, just knowing the condition and violating it is enough.
Now we come to appeals and post-conviction proceedings, which can sometimes unfold years after a trial has concluded. What's the prosecutor's duty here, especially if questions of innocence arise? This seems critical.
Standards 9.1.1 and 91.2 outline that prosecutors involved in post-conviction proceedings consult with trial prosecutors but must exercise independent judgment in reviewing cases. They generally defend legally obtained convictions unless compelled by the interests of justice to take a different course. This balance is crucial. While defending valid convictions is important for the finality of judgments, the overarching duty to justice means being open to reevaluating cases when new, compelling information emerges.
And this leads to perhaps the most profound ethical duty for a prosecutor: addressing actual innocence. This must be a tremendous responsibility.
This truly is the ultimate expression of the Minister of Justice role. Standard 9.1.7 states that if a prosecutor becomes satisfied that a convicted person is actually innocent, they must promptly notify their supervisors and the state's attorney of the jurisdiction. If agreed upon after review, they must then promptly notify the court and seek the person's release if incarcerated. Similarly, Standard 9.1.8 requires that if a prosecutor becomes aware of new, material, and credible evidence, creating a reasonable probability that a convicted defendant did not commit the offense, they must promptly report this internally.
What's the definition of reasonable probability in this context? That seems like a key threshold.
The standards clarify that reasonable probability is defined as a probability sufficient to undermine confidence in the outcome, borrowing from well-known Supreme Court cases. If we connect this to the bigger picture for public policy, these standards represent a profound commitment to justice, even years after a conviction. What's truly remarkable here is the active, explicit obligation for prosecutors to correct past errors, even if it means overturning a hard-won case. This is a critical safeguard for public trust and a testament to an evolving justice system that prioritizes truth and fairness above all else. #outro. So this deep dive into the Connecticut prosecution standards really reveals a remarkably robust and evolving framework. It clearly defines the prosecutor's role not just as an advocate, but as a true minister of justice. From navigating the complexities of implicit bias in jury selection and the proactive reporting of misconduct, to the solemn duty to address actual innocence, these standards truly aim to uphold the highest ethical and professional conduct across the entire division of criminal justice.
So what does this all mean for you, whether you're delving into public policy for PP 5340, managing organizations, or just intensely curious about how justice is administered in our society? It shows that the rules governing the people who wield immense power in our legal system are incredibly detailed, constantly evolving, and painstakingly designed to balance the interests of society with the fundamental rights of individuals. It raises an important question for all of us, I think. In a world of increasing information, scrutiny, and public demand for fairness, what more can we as citizens, policymakers, and legal professionals do to ensure these high standards are not just written, but truly lived every single day in every courtroom across the state? That's all for this deep dive into the Connecticut prosecution standards. Thank you for joining our study group for PP 5340 Introduction to Public Policy and Management. Keep digging, keep questioning, and keep learning. We'll see you next time on the deep dive.